Namaste, hello, and welcome to today's Explainer. If you're currently prepping for your law exams, you've probably realized by now that the law of torts, well, it looks pretty simple on the surface, but it's actually quite a tricky, uncodified beast of a subject. But don't worry, because today we're going to completely demystify these so-called civil wrongs. We are going to break these concepts down so clearly that you'll literally be able to spot a tort from a mile away.
Okay, let's just dive right into a super relatable scenario. Imagine your friend is about to sit down and you pull the chair away just for a laugh. They fall with a massive thud. Now, while pulling a chair might just seem like a goofy schoolyard prank to you, in the legal world, this intentional act introduces us directly to the concept of a civil wrong. You see, you deliberately interfered with their right to sit safely.
We've got a massive syllabus to cover, so we've mapped out a crash course, broken down into 6 logical sections. Understanding the civil wrong, torts, crimes and contracts, the essential elements, intentional wrongs and negligence, general defenses and torts, and finally, strict and absolute liability. Let's get into it.
Section 1. Understanding the civil wrong, decoding the origins of torts. Let's start with the absolute basics and figure out what this judge-made law actually is.
So the word itself actually comes from the Latin term tortum, which literally translates to twist. Think of a twisted ear. At its core, a tort happens when someone performs an act in a twisted or, incorrect manner, causing a civil wrong against an individual. And remember, it's an uncodified law. That means you won't find a neat little rule book passed by Parliament. Instead, it's evolved organically over time through decisions made by judges in courts.
Because it's uncodified, the damages in torts are what we call unliquidated. Now, what does that mean? It simply means the compensation is not predetermined. Think about it. If you're driving carelessly and crash into my tiny Maruti 800, the repair bill is, maybe a couple of thousand rupees. But if you crash into a billionaire's Rolls Royce, that damage is in the millions. The act, crashing the car, is exactly the same, but the compensation varies drastically based on the specific situation. The court figures out the amount based on the actual loss.
Section 2. Torts, crimes, and contracts, establishing the legal boundaries. Now that we know what a tort is, let's see how it compares to the other big legal frameworks you study.
Here's where it gets really interesting, the contrast between private torts and public crimes. A tort is a completely private dispute. If you trespass into my garden, that's just a matter between you and me, X versus Y. The fix is just you paying me damages. But a crime, that's a public wrong. If someone commits a robbery, that threatens our entire civilized society. That's why criminal cases are fought by the state, like X versus the state. And the end goal isn't just compensation, it's punishment and jail time. Plus, torts can happen just through pure carelessness, while crimes usually require a guilty, intentional mind.
We also have to separate torts from contracts. In a contract, the rules and duties are mutually pre-decided by the specific people involved. Like, if I agree to pay you a fee for a 6-month class, we literally created those obligations together. But a tort? A tort involves duties that are fixed by the law for absolutely everyone. I don't need to sign a contract with you to expect that you'll drive safely on the road, right? The law imposes that duty on you toward everyone in the world.
Section 3. The essential elements, the formula for a successful lawsuit. Okay, put yourself in the shoes of the plaintiff, the person who was wronged. How do you actually prove a tort happened in court?
You absolutely must satisfy this exact 3-step checklist. First, the defendant has to have committed a wrongful act, or an omission, meaning they failed to do something they were legally supposed to do. Second, that act must have caused a legal injury, meaning it directly violated a specific legal right you hold. And third, you have to be seeking unliquidated damages as your remedy. If you can't prove that second step, the violation of a legal right, your whole case just falls apart.
To really wrap our heads around that second step, let's look at a famous legal maxim. Injuria sine damno. Sounds fancy, right? It just means legal injury without actual damage. The ultimate example is the historic case of Ashby versus White. A police officer wrongfully stopped a man from casting his vote. Now, the candidate the man wanted to vote for actually ended up winning anyway, so the guy suffered 0 financial or physical damage. But the court still awarded him compensation. Why? Because his legal right to vote was violated. In torts, the violation of the right is the whole point.
On the flip side, we have damnum sine injuria, damage without a legal injury. The Gloucester Grammar School case is the perfect example here. Imagine you run a really successful school. Suddenly, a rival opens up a brand new school right next door, and they completely slash their fees. All your students leave, and you suffer massive financial damage. Can you sue them for a tort? Nope, because simply setting up a competing business and offering cheaper prices doesn't violate any of your legal rights. You suffered damage, sure, but no legal injury actually occurred. You won't get a single rupee.
Section 4. Intentional wrongs and negligence. From pulling chairs to spreading gossip, let's look at some specific everyday examples of these wrongful acts.
It is super important to recognize how everyday actions map directly to the law. Take assault and battery. People use these words interchangeably all the time, but legally, they are totally different. Assault is merely creating the fear or apprehension of violence, like raising your hand at someone so they flinch. Battery is the actual physical contact. Think of Virender Sehwag at the crease. When he swings his bat and actually smashes the ball, that physical contact, that's battery. Then there's false imprisonment, unlawfully locking someone in a room, even as a joke. And trespass, which isn't just jumping a neighbor's fence. It can also be keying someone's parked car, which is trespassing on their movable goods.
And what about defamation? Whether it's the written form, libel, or the spoken form, slander, the golden rule you have to remember is reputation lies in a third person's eyes. If I call you up on the phone and hurl terrible insults at you privately, that is absolutely not defamation. Why? Because your reputation in society hasn't been damaged. Gossip only transforms into the tort of defamation when a third party actually hears or reads it.
Section 5. General defenses and torts, the defendant's protective shield. So, what if you're the one being sued? Are you just doomed to pay up? Let's see how you can protect yourself.
The law actually provides a toolkit of general defenses to act as your shield. If you can prove you had statutory authority, like the government authorized your action, you're safe. If you trespassed out of necessity, say running through a neighbor's yard to escape a raging fire, you're protected. Or take volenti non fit injuria, which basically means voluntary consent to risk. If you buy a ticket to a high-speed motor race and a rogue tire flies into the stands and hits you, you generally can't sue. You voluntarily assume the known risks of being there.
Now, students mix up these next two defenses all the time. Both apply when things go terribly wrong, but they are very different. An inevitable accident is a mishap that happened even though you took all normal precautions, like a sudden, totally unforeseeable brake failure in a regularly serviced car. But an act of God, or vis major, requires absolutely zero human intervention. It has to be an extraordinary, purely natural force. A standard rainy day causing a fender bender, not an act of God. But a 50-year record-breaking flood that sweeps a house away, that is an act of God.
Finally, Section 6. Strict and absolute liability, when intention doesn't matter. This is where we escalate to the most severe scenarios in torts, where you're responsible even if you took every possible precaution.
Let's look at strict liability, which stems from the historic British case of Rylands versus Fletcher. A guy built an artificial reservoir on his land. Well, the water unexpectedly broke through some old abandoned mine shafts and completely flooded his neighbor's active coal mine. Even though he didn't intend it and he had hired professional contractors, the court held him strictly liable. The rule is straightforward. If you bring something inherently dangerous onto your property, use the land in a non-natural way, and that dangerous thing escapes and causes harm, you are paying damages. But here's where Indian law did something incredible. You see, strict liability had a major flaw. Too many loopholes, like exceptions for acts of God or a stranger sabotage. Following the absolutely horrific Bhopal gas leak, the Indian Supreme Court, led by the MC Mehta case, realized that massive corporations dealing in hazardous materials could not be allowed to hide behind these exceptions. So they created absolute liability. In India, if an enterprise is engaged in a hazardous activity, their liability is absolute. There are no exceptions whatsoever. And the dangerous thing doesn't even need to escape the factory to trigger liability. If workers inside are harmed, the company is liable.
And this ties directly into what Indian courts call the deep pocket theory. Under absolute liability, the damages aren't just about compensating the victims. They are exemplary, meaning the larger and richer the enterprise, the heavier the damages they have to pay. The whole point is to set a massive financial precedent so that giant corporations never, ever take public safety for granted again. Well, we've certainly covered a ton of ground today, all the way from the basic twist of a tort to the absolute liability of mega corporations. I really hope this breakdown has clarified the essential elements and defenses you're going to need for your exams. So I want to leave you with this one thought. The next time a friend pulls a chair out from under you or spreads a rumor, are you just going to laugh it off? Or are you going to start calculating the unliquidated damages for their civil wrong? Best of luck with your exam prep and keep seeing the world through that legal lens.